Perhaps I should start with you, Ms. Mnisiwik, because you've since issued a statement welcoming the pronouncements by the Minister of Women, Children and People with Disabilities, Lulu Xingwana, and saying that you support her views on the issues surrounding the Traditional Courts Bill. Why?
Well, the primary reason is that the Traditional Courts Bill is definitively bad for women. It doesn't provide for women's participation in decision-making in traditional courts. It doesn't provide for women to be able to represent themselves in traditional courts when they are litigants, which is a major concern that women often list as a problem that they encounter in traditional courts, that they have to be represented by male relatives, and find that this disadvantages them, especially in cases where those very same male relatives are the ones who have violated their rights. It doesn't take care of a number of substantive issues that women encounter in some traditional courts, where often women report that when they bring domestic violence cases, for instance, they don't get a sympathetic hearing from the traditional courts because those traditional courts are primarily comprised of older men who are less understanding of women's concerns than they are of the male relatives' concerns. But the big trump is the fact that the Traditional Courts Bill was drafted without consulting rural women as a separate interest group in safe spaces where they can speak freely about their needs and their concerns and what would address their access to justice.
But you know what I've heard? I've heard people who support the Traditional Courts Bill suggesting that the activists are very, they generalize around these issues. They seem to accept that what may have happened in one particular locality happens across the board in terms of participation of women in decision-making and participation in the process generally.
I think that that's an unfair critique. The reason being that we don't say that this happens everywhere. We say that it happens in numerous places, and there are documented accounts thereof. But the most significant thing here is that the law's role is not to provide for those instances where things are going well. The law's role is to protect those people who are in places where things are going very badly. And as a consequence, that's why we focus on those instances when we are criticizing the bill.
Yeah, but the question is, if you were then to focus on those areas where there are these problems and make sure that you have a uniform way of doing things across the board as opposed to changing the bill itself, would that satisfy you?
I don't know that you can have a uniform situation without actually changing the bill. But I think as far as changing the bill, what we're calling for is a bill that is founded on the views of rural women, not on the views of those people who rule them and actually in many cases stand to benefit from the flaws with the bill. Because things like the fact that the traditional leader is the only person who's really effectively given a role in dispute resolution and in the making of customary law according to the bill, that is something that would benefit the traditional leader, and if he's the only person who gets to say on that, that's a problem.
Okay, let me bring in Nkosi Holomisa and start exactly on that point, or of the role of a traditional leader here, which is a criticism of this bill here. Nkosi Holomisa, how do you respond as the traditional leaders of South Africa?
Well, the intentions of the bill are good, because if you look at the long title of the bill, it indicates that the bill is intended to enhance the ability of the African way of justice administration to bring about justice to the people. It reconciles those who are fighting. It promotes harmony within the community. It is inclusive in that everybody has a role to play in the processing of cases before the court. It also brings about the need for democracy because, as I say, everybody is allowed to participate.
And I think that's the key. The key is inclusiveness.
Yes.
Are women included?
I'm saying that is the intention. The bill does have shortcomings because it's assumed, the bill has assumed that the provision of the Traditional Leadership and Governance Framework Act regarding the composition of a traditional council is going to be the structure that is going to become the traditional court. But it doesn't say it in so many words, because the traditional councils are required to be composed of a number of sectors within the community: people with disabilities, the aged, the youth, as well as women. It specifically says that the number of women in this court should not be less than 1/3 of the entire council, which means, therefore, that women are given an opportunity to participate in this bill as women. So this bill doesn't say it in so many words. It assumes, because currently these courts are operating, in fact. It's not as if something new is being created here.
Yeah, but in their current operations,
Yes.
there is a widespread held belief that actually they are oppressive to women.
Well, traditionally, that has been the position, that these courts have to be composed of men, elderly men within the community. But it has been changing. The situation has been changing on its own. Women do participate in a number of ways in these courts. But it's not quite true that the bill precludes women from representing themselves.
Well,
it specifically says that women can represent themselves, but if they want to, they can get somebody from within their family or whoever they choose to represent them. It's not as if it's an additional... I listened to you, Cindy, so when you spoke, I didn't interrupt. It specifically, it actually adds another right, because you can represent yourself as a woman, but if you like, you can have a family representative representing you.
All right, fine. We're gonna go back to Cindy in a minute, but Mbuyiselo wrote an article here. His view is that the bill is the antithesis of all the things to those who have paid the ultimate price in this country stood for.
Absolutely, I mean, the essence of the bill, very oppressive, in that, it does not allow women to, opt out. If I'm a woman in the traditional court bill, and I feel that, but this is unfair, and in this process, I don't even agree with this process. I am not allowed to go to a magistrate court, because I am supposed to agree with whatever takes place in that court. And our view is that, and at a substantive level, and I think Nkosi has considered that it is flawed, and our call is that even
he says the intentions though are good.
Yeah,
he says it was well intentioned.
I'm not even sure that these intentions are good, because, as I say and argue in that piece, is that we know that, you and I, that who in the main are traditional leaders and are men, and
but he says the situation is changing itself.
But I am not even sure. We went throughout the 9 provinces. We went to all the hearings, and the situation has not changed one iota. So it's not a true reflection what Nkosi is saying, because in all the hearings we went to, women themselves in those deep rural areas were in fact saying, but these, in the present forms, they are extremely misogynistic, extremely oppressive when I call on.
Cindy, so you wanted to object to one or two things?
Yes, I wanted to object primarily to the factual allegations that Nkosi is putting forward around the fact that the bill allows women to represent themselves. The bill does not specifically say that women can represent themselves. In fact, it simply says that men can be represented by women, and as women can be represented by men in accordance with customary law. And as somebody who's studied customary law for a very long time, I can tell you that throughout the country there is basically no place where a man is represented by a woman according to customary law, but women are very often, in fact it is the most common position, that women are required to be represented by men. And so if the bill says that the position according to customary law can persist, what it is effectively saying is that women can continue to be represented by men without actually requiring that women be allowed to represent themselves.
It's quite technical though, because you need to go back and just say it again. Men can represent women and women can represent men.
Yes, but the thing is that the law is a technical thing, so I'm really perplexed when Nkosi Olomisa then says the bill doesn't specifically say that traditional councils can serve that function. It just assumes. The law is not based on assumptions. There is no court that is going to give effect to an assumption. The courts work on the basis of what is in the text and what can reasonably be read into the text. And I would say that as a lawyer, this argument that Nkosi is putting forward would not fly.
Nkosi is also a lawyer.
I agree.
No. Let's get to the substance.
Please do, Nkosi Olomisa, because also
because you
without
say,
being too technical.
I've said it that the bill has shortcomings. One of them is that very point that Cindiso is making here, that the bill doesn't say it in so many words. So necessarily, therefore, the bill has to be changed in order to make it clear that the traditional councils, which are inclusive, are sensitive to gender issues, have to be accommodated. There's this point that was made by Mbuyiselo there, about women not given the
right to opt out.
Right to opt out. I don't understand this thing at all.
Let's talk a little bit about that.
You see, if you have committed an offense, and the court that is required to deal with that offense is the magistrate's court, or is a high court presided over by judges, or the labor court, or any other court, you don't have a choice. You go to that court. You present your case, you defend yourself if you are the defendant, and then a decision is taken. If you are not satisfied with the decision of that court, you appeal to another court. So I don't understand why it is now that there's suddenly a question of opting out. You don't opt out. You don't opt out from going before a magistrate's court if you are required to go before a magistrate's court, because these courts, Xolani, are indigenous courts. They are African courts. They have been there.
All right.
Now, people level criticism at these courts as if they are bringing about injustice, and yet they don't ask themselves the questions why it is that you have to have money in order to get a justice in
all right.
court.
We'll talk about that. We'll talk about that. The extension of the current system, the current system that we use in terms of the Dutch law and whatnot. But please come back to this issue of opting out. Yeah. Why should there be an opt-out clause? I'm
saying maybe I want to ask Nkosi as to why, when I feel aggrieved that in this traditional court that I don't think that my matter has been handled satisfactorily, that I am not allowed to go to the magistrate court. I want Nkosi to answer that question.
Yeah, I'm saying you can always appeal against the decision of any court in the country, except the Constitutional Court, if you are not satisfied.
But if I choose right at the onset not to go to a traditional court, what do I do?
Why must you choose? If you have committed an offense that is within the jurisdiction of the Court of Traditional Leadership, why should you opt out?
But why?
Do you opt out from a magistrate's court's jurisdiction?
Can I jump in here?
Yeah, come in, Cindy.
Okay. Well, I'd like to offer two things. The first is to actually extend Mbuyiselo's argument beyond claiming the right for an opt-out, but rather to claim a right for an opt-in. And I think the primary basis for this we find in our Constitution. Unlike the national courts or the general courts of the land, as Inkosi Olumisa wants to equate traditional courts are not the national courts of the land. And according to the Constitution, culture is something that you get to choose. There are two rights in our Constitution that protect culture. There's an individual right and there's a group right, and both of them are framed in such terms as to say that it is up to the individual to choose whether or not they want to perpetuate their culture. And as a consequence, I think that that's a very significant basis on which we can say people have the right to choose whether or not they want to go to a system of courts that will enforce customary law. And so I think to argue about an opt-out clause is not the right focus. The focus is that people should be allowed to choose. And another reason for people being allowed to choose is the fact that unlike the courts, the general courts of the land, traditional customary law is typically very localized, which means that there's less opportunity for people to know in advance what is and isn't the law. And here I draw attention to the fact that the Traditional Courts Bill doesn't envision that only people who live in those areas would be subject to those courts, but even passes through people who wouldn't have known.
Make me understand this argument about people not knowing in advance what may or may not be law, because presumably if you live in that area you would know what is law and what is not.
The point is that you don't even have to have lived in that area for you to be subject to those courts and not be allowed to opt out. You could just be someone who is passing through, who has broken a law in that area without having known what that law was in advance, and you would still not be allowed to opt out, to choose to go to a different court to have your case heard.
Now we are being blamed here for the fact that the system that we have inherited and the one that they want to perpetuate has failed to ensure that people of South Africa are taught about the laws of the land. The laws of the land, Xolani, are the laws of the people of South Africa, the indigenous people of South Africa, not the imposed ones. Now, the fact that lawyers are not trained about African law, judges are not trained about African law, and that the people who are the repositories of these laws are the rural communities. Now that is used against this